If police ask, "Do you have a weapons?" lawyer breaks down the right response. A police officer is standing at your car window right now. His hand is resting on the door frame. His eyes are scanning your vehicle. And he asks you the question that makes every gun owner's stomach drop. Do you have any weapons in the vehicle? Your heart rate doubles, your palms go wet, and in the next 10 seconds, you are going to either protect yourself completely or hand that officer everything he needs to ruin your life. Here is what nobody tells you. Most people think there are only two ways to answer this question, yes or no. But as someone who has spent years inside courtrooms watching good people get destroyed by their own words, I am telling you right now, both of those answers can be a death sentence for your legal rights. Say yes, and you have just invited a high-tension situation that escalates in ways you cannot predict or control. Say no when you have a licensed firearm in your glove box and you have just committed a crime by lying to a law enforcement officer. In most jurisdictions, that is a charge that compounds everything else you might be facing. There is a third option, a precise legal response that stops the interrogation cold while keeping you safe, keeping you respectful, and keeping every single constitutional protection you are entitled to fully intact. I am going to give you the exact words, but before I do, I need you to understand something that took me years of practicing law to fully appreciate. Most gun owners do not lose their rights because they are criminals. They lose their rights because they talk too much. And after you hear what I'm about to share, you will never make that mistake again. Picture so accurate, it is going to feel like I was sitting in your back seat. You are coming home from a long Saturday. Maybe you are at the range. Maybe you just finished a hunting trip. Maybe you simply carry every day because that is your right and you take it seriously. Your firearm is exactly where it is supposed to be. Your permit is valid. You are by every legal definition doing nothing wrong. Blue lights appear in your rearview mirror. Broken tail light, expired registration sticker, maybe you rolled a stop sign, does not matter. You pull over, you take a breath, you remind yourself you have nothing to hide. The officer approaches. He is professional, but his hand is resting near his belt. He asks for your license and registration. And then before you can even fully process the situation, he drops the question that changes everything. Do you have any weapons in the vehicle? And here's what the good, honest, responsible gun owner says. Yes, sir, I have a handgun. It is in my center console. I have my concealed carry permit right here. It is loaded, but the safety is on. I just came from the range. I have had my permit for 6 years. I am not looking for any trouble. Sounds reasonable. Sounds cooperative. Sounds like exactly what a law-abiding citizen should say. Right, wrong, dead wrong. You just handed that officer 9 separate pieces of information he never asked for. And each one of those pieces is a legal landmine that can detonate in ways you never saw coming. You said it is loaded. What if your state classifies loaded differently than you think? What if having a round-chambered versus a magazine inserted falls under a completely separate statute? You just potentially confessed to a transportation violation. You said the safety is on. What if the officer later writes in his report that you told him the weapon was accessible and ready to fire? That is a different story. That is his word against yours. And guess whose word a jury tends to believe? You said you just came from the range. Now the officer is wondering why you did not unload before leaving. Now he is asking follow-up questions. Now you are explaining yourself under stress, building a narrative you cannot control. But here is the part that most concealed carry courses never teach you. The word weapon itself is a trap. In some jurisdictions, a screwdriver in the footwell is a burglar tool or a concealed weapon. A heavy flashlight can be classified as a bludgeon. By engaging with that question directly, you are playing a game where the officer defines the rules and the definitions, and you do not even know what rule book he is using. This is why criminal defense attorneys see the same story over and over. Good people, legal gun owners, no criminal intent whatsoever, sitting across from us in our offices wondering how a broken taillight turned into a felony charge. And the answer is always the same. They talked. Here's something they do not teach in any concealed carry course. When a figure of authority asks you a direct question, your brain experiences something called compliance pressure. It is hardwired into you from childhood. Teacher asks a question, you answer. Parent asks where you have been, you explain. Authority figure speaks, you respond automatically. That hardwiring overrides your legal judgment completely at the car window. Your brain tells you that silence looks guilty. Your brain tells you that explaining yourself will fix the situation. Your brain tells you that if you are friendly enough, cooperative enough, transparent enough, this officer is going to smile and send you on your way. But your brain is wrong. The officer is trained to ask open-ended questions. He is trained to let silence hang in the air so you feel it. He is trained to follow friendly, comfortable people. Keep talking. And everything you say, everything goes into a report that a prosecutor will read later, looking for inconsistencies. When an officer asks if you have weapons, he is not just making conversation. In the legal world, this is a consensual encounter rapidly transitioning into what we call a Terry frisk or a full vehicle search. He is fishing for probable cause. And your answer, however honest, however friendly, however well-intentioned, is exactly the bait he is fishing with. That is not a conspiracy. That is just how the system works. And understanding how it works is the only way to protect yourself inside it. Now, let me give you the legal foundation these words stand on. Because if you do not understand why they work, you will not say them with confidence. And if you do not say them with confidence, they will not protect you the way they need to. The Fifth Amendment to the United States Constitution protects you from being compelled to be a witness against yourself. You have heard the phrase, pleading the Fifth. You probably associate it with courtrooms and criminal trials. But that protection does not begin at trial. It begins the moment law enforcement starts asking you questions. The Supreme Court has been extraordinarily clear on this point. You have the right to remain silent during a police encounter. Not just after arrest, not just in a courtroom, during any interaction where your words could be used against you. Now let us talk about the Fourth Amendment. The right against unreasonable search and seizure. Here is something most gun owners do not know. An officer cannot search your vehicle simply because he wants to. He needs consent, probable cause, or a warrant. When you volunteer information about your firearm, you are potentially providing the probable cause he needs to justify a deeper search. You are essentially handing him the legal key to your entire vehicle. And then there is Terry versus Ohio. This is a 1968 Supreme Court case that governs what is called a Terry stop or investigative detention. Under Terry, an officer who has reasonable, articulable suspicion that you are armed and dangerous can conduct a pat-down search. Notice those two words carefully, armed and dangerous. Not just armed. Legally owning a firearm does not make you dangerous, but the moment you tell an officer you have a weapon, you have confirmed the armed part of that equation. And now the dangerous determination lives entirely in that officer's subjective judgment in a high-pressure moment on the side of a road. Why would you give him half that equation when the law says you do not have to? Furthermore, the moment you admit to a weapon, that officer's threat assessment jumps from level 2 to level 10. His training kicks in. From that point forward, every movement you make, reaching for your registration, adjusting in your seat, turning your head, is filtered through the lens of a person he now knows is armed. This is where situations escalate. This is where tragedies happen. Not because you did anything wrong, but because the information you volunteered changed the entire dynamic of the encounter. So, here is what you say instead. When a police officer asks, "Do you have any weapons in the vehicle?" here is your response. I don't answer questions. That is it. 5 words. No hedging, no apology, no explanation attached. I know what you were thinking. That sounds rude. That sounds aggressive. That sounds like something a guilty person says. I need you to understand something. That reaction, that discomfort, is exactly what the system is counting on. It is designed to make exercising your rights feel socially unacceptable. because people who feel uncomfortable invoking their rights tend to stop invoking them. Let me be very clear about what those 5 words actually communicate. They are not hostile. You are not raising your voice. You are not accusing the officer of anything. You are not making his job harder in any unlawful way. You are simply and clearly invoking a constitutional protection that exists precisely for moments like this one. And here's the most critical thing from a legal standpoint. You are not lying. Lying to a law enforcement officer is a crime in most jurisdictions. Saying no when the answer is yes can result in charges that compound everything else you might be dealing with. But I don't answer questions is a true statement. You are doing exactly what you said. You are not creating a false record. You are not giving anyone anything to use against you. Now, some attorneys will tell you the phrase to use is, I do not permit searches. Here is why both phrases work together and why you need to understand the logic behind them. I don't answer questions invokes your Fifth Amendment right. It stops you from becoming a witness against yourself before any charge has even been filed. I do not permit searches invokes your Fourth Amendment right. It creates a clear on their statement on the officer's body camera that you did not consent to any search of your vehicle. Using the logic of both is what gives you complete protection. Because here is the chess game being played. If you say, no, I do not have any weapons, the officer's natural follow-up is, well, if you have nothing to hide, you do not mind if I take a quick look, right? And now you're either consenting to a search or you look like you just lied. But if you lead with, I don't answer questions, and follow with, I do not permit searches, if a search is requested, you have closed both doors cleanly and lawfully. Now, let us walk through what happens next in real time, because this is where most people fall apart. Even when they know the right words, they say them and then panic in the silence that follows. The officer says, Sir, I just want to make sure we're both safe here. This is reasonable, and you should treat it as such. You nod. You keep your hands at 10 o'clock and 2 o'clock on the steering wheel where he can see them completely. You say calmly, I understand, officer. I don't answer questions. Then you stop talking. You do not add anything. You say it and you go quiet. The officer says, Are you refusing to cooperate with me? This is a pressure tactic. It is designed to make you feel like you are doing something wrong. So you will start talking. Your response, I'm cooperating fully, officer. I'm just not answering questions because that is the truth. You have your hands visible, you have your license and registration ready. You are following every lawful instruction. Cooperation and silence are not mutually exclusive. Do not let anyone convince you otherwise. The officer says, if you won't answer me, I'm going to assume the worst. This one is designed to trigger fear, and it works on people who do not know their rights. Your response: I understand your concern, officer. I don't answer questions. Calm, consistent, unshakable. Here is why this works. What the officer assumes is not evidence. What you say is, so let him assume. His assumptions cannot convict you. Your words can. The officer says, look, this will go a lot easier for both of us if you just talk to me. Your response, I appreciate that, officer. I don't answer questions, polite, firm, done in the majority of routine traffic stops. The officer will run your license handle, the reason for the stop, and move on. Most traffic stops are exactly what they look like. Minor infractions, stay calm, stay quiet, stay respectful, and most encounters end exactly as they should. Now let us talk about body language, because this is the piece nobody puts in the same conversation as legal strategy, and it absolutely belongs there. You can say the right words in the wrong way and create a situation that spirals anyway. Your hands are visible at all times, 10 and 2 on the wheel from the moment those blue lights hit your mirror until the officer walks back to his car. If your hands need to move, you narrate it. My registration is in my glove box. I'm going to reach for it with my right hand. Pause. Wait for acknowledgement, then move slowly and deliberately. Your voice is level, not too quiet, which reads as nervous, not too loud, which reads as aggressive. Conversational, steady, the same tone you would use ordering coffee. Your face is neutral, not smiling aggressively, which reads as anxious, not stone-faced, which reads as hostile, just present, just calm. Your body stays still. No fidgeting, no shifting, no looking around. Motion creates concern. Stillness communicates control. This combination, the right words with the right body language, transforms your response from something that sounds confrontational into something that sounds exactly like what it is, a common person exercising a constitutional right. The officer reads your body as much as he hears your words, makes sure both are saying the same thing. Now, there is a critical exception to everything I just told you, and I will not skip over it because getting this wrong can be just as dangerous as talking too much. Roughly a dozen states have what is called a duty to inform law. These states legally require you to notify a law enforcement officer that you are carrying a concealed firearm when you are stopped. States including Ohio, Texas, Louisiana, Michigan, and several others. If you are in one of these states and you are carrying, you are legally obligated to disclose. Failing to do so is itself a crime. But here is what those laws do not require. They require disclosure. That is it. One statement. They do not require you to answer follow-up questions about where the gun is, how it is loaded, why you carry, or how long you have had your permit. Here is exactly how you handle a duty to inform state stop. Before the officer even asks anything, as he approaches your window, you hand him your driver's license, your registration, and your concealed carry permit together as one package. You say, "Officer, I'm required by law to inform you that I have a valid concealed carry permit and I am currently armed." Then you put your hands back on the steering wheel and you wait. If he asks where the weapon is, you say, "I prefer not to answer further questions, but I will follow any instructions you give for everyone's safety." You have done everything the law requires. You have offered to follow safety instructions. You have given him zero additional ammunition for a follow-up investigation. Inform is required, then stop. That is the duty to inform executed correctly. What most gun owners do instead is inform and then keep explaining. Every single additional word is a gift to a potential prosecution that you wrapped and handed over yourself. Now let us talk about what happens if the situation escalates beyond a verbal exchange. Because sometimes knowing the right words is not enough and you need to know what comes next. If the officer says, "Step out of the vehicle," do not argue, do not say why. What did I do? I told you I do not consent. Under the Supreme Court case, Pennsylvania versus Mims, an officer can order you out of a car for any reason during a lawful traffic stop for officer safety. You cannot legally refuse to step out. Arguing against a direct lawful order moves you into resisting territory, and that is a charge you do not want. But how you step out matters enormously. Here is why the officer wants you out of the car. When you are sitting in the driver's seat, your body blocks a significant portion of the interior. When you step out, the officer gets a wide-angle view of the floorboards, the side pockets, and the space between the seats. If you leave your door wide open as you exit, you have just provided a visual search of everything inside that car through what is called the plain view doctrine. If he sees anything even remotely suspicious, a shell casing on the floor, anything in the ashtray, he now has probable cause, and your Fourth Amendment protection is effectively deactivated. So as you prepare to exit, do this: roll your window up nearly all the way, leaving just a small crack for communication. Grab your keys and your phone. Step out and immediately lock and shut the door behind you. By shutting and locking that door, you have reestablished your reasonable expectation of privacy for the interior of that vehicle. If the officer wants back in, he now needs a warrant or your consent, and you are not giving consent. The moment you are standing on the side of the road, the officer will likely try to keep the encounter going. He will ask where you are coming from tonight, why you look nervous, where you are headed. This is where you deploy what every experienced defense attorney considers the most powerful verbal tool in your arsenal during a traffic stop. An officer conducting a paytown is looking for weapons. If he feels something in your pocket and it is immediately apparent as contraband, he can seize it. But if he has to squeeze, manipulate, or probe the object to determine what it is, he has just conducted an illegal search. Know the difference so your attorney can use it. Now let us talk about the 10 minutes after the stop, because most people drive away and let the memory fade. That is a mistake. The moment you are safely away from the scene, pull over at the nearest gas station or parking lot. While the memory is completely fresh, open your voice memos or notes app and record everything. The officer's name and badge number, if you caught it, the exact time the stop started and ended, exactly what you said, and exactly what the officer said, any pretextual language the officer used, things like you looked nervous or your hands were shaking, any instructions you were given, and how you responded. This contemporaneous record is incredibly powerful. When an officer testifies 6 months later, he will not remember the specific details of a routine traffic stop among hundreds he has made since then. He will say the suspect was acting erratic or appeared nervous. You will have a time-stamped voice memo from the day of the event saying you were calm, hands at 10 and 2, and the officer never mentioned your behavior until the 3rd minute of the stop. That is the kind of detail that changes outcomes in courtrooms. There is a phrase that every criminal defense attorney knows by heart. Write it down if you need to. You cannot talk your way out of an arrest, but you can absolutely talk your way into one. Every case involving a legal gun owner facing serious charges had a moment. A moment at a car window, a moment where they said something they thought was helping them, something honest, something cooperative, something completely reasonable in their own mind, and that something became the foundation of a case against them. Prosecutors are not looking for guilt in the field. They are looking for a threat to pull. And your words during a traffic stop are the most accessible threat there is because they are documented. They go into a report within hours. They get reviewed by people whose entire job is to find an angle. Do not give them the threat. Remember this clearly. The police have the handcuffs, but you have the Constitution. These are not opposing forces. They are meant to work together. The founders built these protections into the supreme law of this country because they understood from personal experience what happens when citizens have no shield against the power of authority. The Fourth Amendment, the Fifth Amendment, these are not technicalities. They are the architecture of a free society. Invoking them does not make you a criminal. It does not make you uncooperative. It does not make you dangerous or suspicious or guilty of anything. It makes you someone who understands the system well enough to operate within it safely. One final thing, and this is non-negotiable. If you are ever in a situation where a stop has escalated, where you have been searched, where you have been detained beyond the routine, where an officer has become hostile or irrational, comply physically and survive. You cannot fight a legal battle from a hospital bed. You cannot challenge an unlawful search from a casket. Get home, then call your attorney before you say another word to anyone in law enforcement about what happened. Your attorney can file a motion to suppress. Your attorney can challenge the probable cause. Your attorney can use the body camera footage, the stop timeline, your contemporaneous notes, and your silence during the stop to build a defense that protects you. But only if you gave them something to work with. And the best thing you can ever give your attorney is this: a client who kept quiet. So let us lock all of this in permanently. The moment blue lights appear in your mirror, hands go to 10 and 2 and they stay there. License, registration, and in duty to inform states your concealed carry permit ready to hand over immediately when the question comes. And if you carry long enough, it will come. You respond with calm, level, respectful words. I don't answer questions. If you are asked to step out, you comply, you roll your window up, you take your keys and your phone, you shut and lock the door behind you. If the questioning continues outside the vehicle, you ask the single most powerful question available to you. Officer, am I being detained or am I free to go? If you are patted down, you do not resist. You say clearly, I am not resisting, but I do not consent to this search. After the stop, you pull over and you document everything while it is fresh. And before you speak to law enforcement again about anything related to what happened, you call your attorney. That is the complete playbook. It fits in your memory. It is completely legal. It is completely respectful. and it is built on 200 years of constitutional law that exists specifically to protect you in exactly this moment. You are a law-abiding gun owner. You earned that right. You respect that right. And that right comes with another right that is equally important and equally protected: the right to stay silent. These two things do not conflict. You can be a responsible, respectful, cooperative citizen and still say, "I don't answer questions." Those words are not an act of defiance. They are an act of legal intelligence. They are what a person who truly understands the system says when the system puts them in that moment. Stay safe, stay silent,